Welcome to the Detroit Small Business Reorganization Act presentation. This is our fourth for Turnaround Management Association. We'll start briefly, as you can see on the slides. This is brought to you by a large number of sponsors, especially for those who have sponsor passes. You know that this is what it's going to. For those who are here on TMA's extension of a pass, that's what is making this possible. Please take a note of these wonderful organizations that make these kind of presentations possible and keep them in mind. We have some upcoming events in a week or so. I think the Now and Next Gen is going to have the first of its summer happy hours. About a week after that, the 10th annual summer soiree with ACG will be taking place. There'll be a golf outing coming up in mid-June. It's the 27th annual golf outing for TMA. And Now and Next Gen's second happy hour is coming up at the end of June. And if anybody wants these slides after, just email us and we will make sure we get you a copy if you want these dates and such. So today's panel, I'm going to start introducing people here. On the far end here is Judge Joel Applebaum. He's a bankruptcy judge right here in Eastern District of Michigan in the Detroit office. Flint, sorry, an hour. Yeah, it's true. And I've been up there in Flint. My hair is not turning darker as I get older. It's getting whiter as brain cells evaporate. To my left here is Kimberly Ross Clayson. She's with Taft Law, Senior Counsel. She is a Subchapter V trustee for our court. And so she'll bring her personal experience for that to the talk. And next to her is Brash. Matthew Brash is Managing Director of Newpoint Advisors. He's also a Subchapter V trustee. And for the people in the audience who are wondering about Subchapter Vs, you do not have to be an attorney to be a Subchapter V trustee, and he will bring some perspective from that, and also how things are going in Northern District, Illinois, which is only a few hours to our south in Chicago. And of course, I'm Ron Spinner. I'm a principal here at Miller Canfield in the Bankruptcy and Workout group. So I'm going to give a quick overview of Small Business Reorganization Act while the panelists finish up, and then we'll turn to the real experts to answer a lot of questions as we go forward. But to give you a quick background, I'm going to move through this a little quickly. Again, it'll be in the slides if you want to come back. But this act was created in 2019, had a 6-month delay before it took effect, and took effect February 19th, 2020. We literally gave, I think, one of the first presentations on it in this room about the time that this took effect. And then COVID came along. So our goal is to not have another pandemic follow this presentation. The idea was to create a Subchapter 5 to Chapter 11. It is still part of Chapter 11, and that's what if you take nothing else away from this, this is not a different chapter. This is still Chapter 11, and the rules that still apply unless they're specifically modified. It's modeled, though, after Chapters 12 and 13, which means regular traditional Chapter 11 is making sure, it focuses making sure everybody gets paid what they're owed. This focus is more on what can the debtor feasibly pay, and you can't get blood from a stone. And the idea is, once the debtor is given all it can, all its projected income that it can give, that's all you're ever going to get out of it anyway, and that should be sufficient. The slide, there we go. It's designed to be cheaper and faster than a regular 11. They do that by eliminating the unsecured creditors committee, which makes sense because in these smaller cases, there's really not usually an active group of creditors to participate. There's no United States trustees fees, and there's fast deadlines because the longer you hang out in bankruptcy, the more it costs. And there's a way out for the owner as well. If the owner has given a loan on a lien on their house to guarantee business debt, that lien can be modified under a Subchapter 5 case, not a purchase money mortgage, but if you've given a lien for the business, that can be dealt with here as well. But there are fast deadlines. The debtor has to indicate when it files if it's a small business and if it's electing as a small business to proceed under Subchapter 5. And the deadline to challenge that is only 30 days after the conclusion of the meeting of creditors. So if you think later on in the case, oh, I should have challenged it, too late. You need to be on your toes as a creditor because these cases do move quickly. And there's supposed to be a status conference within 60 days of the filing of the petition. Within 2 months, the debtor has to come in front of the judge and explain what they're doing and what their plans are. They have to file a status report 2 weeks prior to that, telling the judge and the court, this is what I'm doing to try to get a consensual plan going. And then they have 90 days to file a plan with the court about how they're going to reorganize. And they can get that extended, but the the general ruling is that it's a little bit harder than traditional. You can't just ask for an extension. It's got to be due to some reason that the debtor shouldn't be held justly accountable for. So there's a bit more of a, it's not just I didn't get to it. There's something happened to push the deadlines back. It happens, and you can get approval, but it's not automatic. So the idea is to keep these deadlines in place and to move this stuff along to get people out. It does not cover everybody. This is not a one-size-fits-all panacea. If you're a single asset real estate debtor, don't bother applying because it won't work for you. It's in the statute. You can't do this. If you are an affiliate of a publicly traded company, as a company, you cannot necessarily file because you're going to be adding all the debts of the affiliates together to see if you qualify. And we'll talk about what the debt limit is in a moment. And the debtor has to be engaged in commercial or business activities, and at least half of its debt has to come from commercial and business activities. Now, as a creditor's attorney, I'll tell you, I find this to be sort of a laughable requirement because theoretically, you just filing a chapter or subchapter 5 does not qualify you as actually dealing with business debts, but almost any other steps you take to wrap up a business debt will count as a business activity. So the bar there is pretty low. The real issue is the debt limit that you have to be aware of. And we'll talk about that in a moment. Creditors do not have the same leverage in subchapter 5 as they do in a regular chapter 11. And that's when you hear creditors pushing back. That's part of the concern that they have. But we'll be talking about some things creditors can do in a minute. So hold that thought. But on the surface, at least, the debtor does not have to pay unsecured creditors in full. A regular Chapter 11 member is focused on making sure everybody gets paid what they're owed before the debtor keeps anything. This is focused more on making sure that the debtor is giving up everything it can afford to give up and not more than that. And therefore, there's no absolute priority rule. So that's a big leverage point in a traditional Chapter 11 you do not have here. You also don't have to have an impaired accepting class. Nobody needs to accept this plan for it to be able to be confirmed if it meets the criterion. And creditors can't take control and file their own competing plan as they will sometimes do in a Chapter 11 case, standard Chapter 11. Here, only the debtor can file. And there's been some discussion about whether that's a little bit too restrictive because sometimes the debtor gets removed. And what happens then if the debtor isn't going to file? But that's, at the moment, debtors cannot file a competing plan. But they are, as I said, still Chapter 11 cases. And one of the big concerns when this first came out was that people would forget that and just try to treat them like a Chapter 13. There's still rules for using cash collateral and borrowing money and all these things that are in Chapter 11, and debtors have to comply with them. And so far, I think the debtors have gotten that, and they seem to understand that there are rules. So that part's good. And they still do need to confirm a plan. Now, the goal of Chapter 11, it's not subtle, Subchapter 5, it's not subtle. They want a consensual plan. The Subchapter 5 trustees, I will politely describe them as kumbaya people trying to get everybody together and make it consensual, even if it's consensually non-consensual. I mean, there's ways to do all sorts of things, but somewhere to get agreement, they will work hard for that. But the focus is try to get people to work it out because it's a lot cheaper if people will agree to things and can, find some happy middle ground. But it can still be done non-consensually. Cram down can happen, and it doesn't require creditor approval, but you do have to go in front of the judge and prove certain extra points beyond the regular ones. You have to prove that the plan doesn't discriminate unfairly and is fair and equitable to dissenting creditor classes. So people who aren't accepting have to be treated properly. It's got to be fair and equitable, and we'll talk a little bit about that. But the requirements for confirmation, they're basically, a lot of them are in the regular section 1129 of the Bankruptcy Code, and most of them are still in force in a Subchapter 5. You still have to comply with the Bankruptcy Code. The plan has to comply with it. The debtor has to comply with it. The plan has to be filed in good faith and not being used as some kind of negotiating leveraging tactic only. There's the fairness test that impaired classes have to get as much as they would get in a subchapter Chapter 7. So if you liquidate the debtor, it's not like that's a better option. If you can show that it would be better to liquidate it, then that's what we're going to do. So those are the thoughts. We'll talk about that a little bit more about what creditors can still do to get some leverage in a Subchapter 5. So if you have a cram down, that's basically meaning that all creditors have not signed on to the plan. There's a possibility of a limited discharge. Debts that are coming due long term are not going to be discharged necessarily. This is not atypical. If you think of a Chapter 13, if they try to save the house, the mortgage exists at the end of a Chapter 13 case. That just you've cured all the defaults and the debtor goes on paying the mortgage after the bankruptcy. That's kind of the same concept here. But there's a bit of discussion about whether or not the fact that there's a limitation on the discharge, does that apply to debtors who are individuals or corporate debtors? And there's some discussion. We're going to talk about that also because that's kind of an odd thing that people are still working through. And there's also the possibility if the debtor is really either incapable or committing bad acts, they can still be removed from control and the trustee can take over if need be. And we're going to come back to, I said that we'll come back to the applies to individuals part. So the bouncing debt limit, this is something we need to talk about because it's coming up soon. The debt limit was originally $2,725,623 of non-contingent liquidated debt, meaning that it's not coming due later, under some weird circumstance, and it's calculable. It's not like something you have to have a court fix, like a tort slip and fall. What is that really worth? It's something you can calculate from loan documents. Why was it this weird number? It's because the number for small business debtor definition had been in the code for many years. It's indexed for inflation under Section 104 of the Bankruptcy Code. And when you index with numbers for inflation over time, you get weird numbers over time. And that just happened to be the number that was kind of carried in. The CARES Act immediately pushed that up, or pretty quickly pushed that up to 7.5 million, which is where the ABI wanted it to be, the American Bankruptcy Institute. And then COVID-19 Bankruptcy Relief Act extended that to March of 2022. But then Congress failed to act, and so it reverted back down to 2.7 million, the original number in the code. And then that automatic indexing came up, and it pumped it up 10%, 10.9% that year, as I recall, to 3 million. So it kind of like a little bit of a bouncing football, what the target is. And of course, the Congress said, oh yeah, we screwed up, and they had their Bankruptcy Threshold Adjustment and Technical Corrections Act, which made it 7.5 million again. Damn it, now it's 7.5 million. And they made it retroactive, so they papered over that immediate little bit of a dip in the code. And now it's going to theoretically sunset on June 21st, and it's going to go back to $3.024 million. Now, you may see some people say 2.7. That's because they have the old figure still in their heads, but it should go back to $3 million. Now, April, just last month, there was a Bankruptcy Threshold Adjustment Extension Act Senator Durbin put in, and after about 6 pages or 7 pages of PDF, the actual operative bit is like one small half of a sentence. It says, where it says expires in 2 years, make it 4 years. I mean, that's literally the entire act that they're looking to pass. And so that would kick it forward. Instead of June 21st, 2024, it'd be 7.5 million to June 21st, 2026. And I don't know the current status of that, but I'm guessing that there's some people who want to make it permanent, and there's some people who don't want to have it extended at all. My guess is when you put something together like this is something Congress say, oh, kick the can down the road 2 years, yep, done. The ayes have it. I expect that'll pass, but I have no knowledge of the future. Anything I say can and will be used against everybody else but me because I take no responsibility for it. All right. So let's talk about some of the more recent case law developments, because for those non-lawyers in the room, the statutes are written to give you the rules, but they can't cover everything imaginable. So there's, they have a definition, such and such happens. And then the question is, well, is this such and such, or is it not such and such? And that's where the judges sort of have to fill in the gaps and kind of give us some understanding of how this stuff is supposed to work. So one of the questions that came up is, can corporate debt be non-dischargeable? And there's a bit of a disconnect here. If you ask all of the bankruptcy judges who've ever ruled on it so far, including one who might be sitting in front of us today, the answer is, of course, you can't have corporate debt non-dischargeable. Corporations, the non-dischargeability provisions of the Bankruptcy Code don't apply to corporations. It literally says in Section 523, if you're an individual pretty much. And so it's, it only applies to individuals. But the way the bankruptcy, the Subchapter 5 part is written, it says you can deny a discharge of the type of things listed in 523. Well, of the type of, is that just a list of the kinds of things, or is it importing all the, whether or not it's an individual? And that's the conundrum. And all the bankruptcy courts have said, Congress didn't mean to change this. Corporations, of course, that get discharged. 2 circuit courts have said, nope, Congress meant to change it. It's discharged. So we're going to see how this plays out. And we'll probably talk about this a little bit this afternoon. Other notes that came out of affiliates. A recent case came out where a debtor had filed his companies into a bankruptcy, and then he wanted to file himself under the Small Business Reorganization Act. And remember, I said affiliates have a problem that you aggregate all the debt. Well, their cases were still out there, and their debts counted toward the limit, and those business debts counted toward his limit, and that was it. He had too much debt to qualify. End of story. So that's something to be aware of. And it's not necessarily even in his control because there was a Chapter 7 trustee who's been in charge of those debts. But nonetheless, that's one of the most recent developments. Subchapter 5 trustee retainer. Some of the people on this panel have some concern and some desire to see that Subchapter 5 trustees get compensated, especially since they are Subchapter 5 trustees and nobody wants to work for free. And the law has a little bit fuzziness in it as far as it doesn't really talk in great detail about how they get compensated. There's discussion of it, but not as clearly as Subchapter 5 trustees would like. For that matter, anybody who has to deal with this. What happens if the case goes belly up and they don't get paid? Well, there's nothing left. There's at least under certain circumstances, they might be able to get a retainer, through the court to make sure that administrative expenses get paid so that Subchapter 5 debtors aren't getting a free ride at the Subchapter 5 trustees' expense. So that was a recent case that will be there. And so if you have these materials, and again, if anybody wants these materials, email me or anybody on the TMA, and we'll get you a copy of these slides. But there's a case that says, yes, you can make sure that the Subchapter 5 trustee gets paid. This non-consensual releases is another big thing people are coming up because it's still Chapter 11, and one thing in Chapter 11, people try to deal with as many debts as possible, even if the people being released aren't necessarily filing their own bankruptcy case. There's no question that if you file your own bankruptcy case, you might be eligible for a discharge. But if you don't file, are you still possible? Can you get the benefits of the bankruptcy without being in the system? And there's a big case, you're all familiar with the opioid case that's going out right now, where people are trying to figure out, can Purdue Pharma grant releases to all of this? I think it's the Sackler family who put all this money into the system to make it work. And so the question is do the ends justify the means? That's the question. The Supreme Court will be wrestling with it. The Subchapter 5, they tried to do that also. And in this recent case, the bankruptcy court said, yeah, it makes sense. I'm going to give this, allow this plan to grant a release. The district court said, no, that's not what it says. You can't do that. Most likely, if you're trying to do that, it's going to be on hold until the Supreme Court gives us some guidance as to whether or not this is permissible or not. If it's permissible, you're probably going to see a lot more of it. And if not, expect a lot of fights if anybody tries it. Other things we're going to, that are yet to be developed. One of the things we talked about is what does it make sense? We are trying to focus on what the debtor can pay, right? That, trying to get no blood from the stone, but get all the blood that you can get, before you turn over the case. That for that, the debtor is supposed to just, contribute all of its projected disposable income. Well, what is projected disposable income? For those financial analysts in here, you can define things lots of different ways. The statute says it's income received by the debtor that is not reasonably necessary for the continuation, preservation, or operation of the business. And if I can't find in this room enough lawyers and accountants who can drive holes through around, all that, of course. So how much does the creditor the debtor get to spend on operations and on marketing? I mean, probably something wasn't being spent on enough marketing. Just hypothetically, that's part of the reason they're in Subchapter 5. Do they get to rebuild the business? How much do they do so at creditor's expense? That's something I'm expecting is going to come up later. But at least one thing that's come out recently is that it probably is a best estimate at the time. You don't have to go back and say, if it turns out the debtor does a lot better than everybody thought, then you don't have to, the debtor probably doesn't have to go back and true up and kick in all the extra money to creditors. It's look at what you got, make your best arguments at the time of confirmation, and everybody live with what's agreed to. One other big thing that's come up recently is lease obligations. So anybody here familiar with a long-term lease, if you sign a lease for, say, 20-year lease and you're in year 3 of it, you're obligated for 17 more years, right? And that's a liquidated debt in the sense that, certainly the obligations are spelled out under the lease and you can figure out how much they are, how long they are. They're not contingent. They're just, you're in that lease. You signed it. Do those count? A lot of those leases can push you over the limit if you're in a small business debtor. And we have now in very short order 2 courts that say 2 different things. One court that said, that's what it says. So if you have a long-term lease, you can't be in Subchapter 5 if that puts you over the $7.5 million limit. And another case that said, that's ridiculous because the debtor may very well decide to reject that lease. and at least maybe an asset. And how can I possibly count it? So on the one hand, that does seem like the right feel, although the law as written doesn't seem to support necessarily, at least in my mind, how that comes out. So it's like you've got kind of a tension there between what people may have intended and what's written. So there may be some clarification that needs to come from Congress, or at least from from case law to set a standard for how things are going. Some statistics. Let's talk about where we're going with this stuff. Why are we all here? We are here because Subchapter 5 is healthy and growing. Some statistics from the recent task force and from our local districts that we have. Small business elections have increased 60% over last year, and regular Chapter 11s are up 40%. So if you any kind of people do math, if you have one group growing, a small portion of a group growing bigger than the whole, it's gaining share. So Subchapter 5, if you want, is gaining share of Chapter 11 overall. And that's true even month to month. Last month, all commercial Chapter 11s were up 5% in number, and Subchapter 5s were up 7%. So it looks like this is not going away. We all need to understand how it works and to deal with it, and that's why we're here. It's not just because of the barbecue. I'll stop at the next one for the Eastern District if you'd like to talk about them. But you'll need to use the mic. And one other statistic, and if you want to, anybody wants to, I should say, if you want to pipe in, please stop me. I don't want to steamroll through. I want to get through because we're a little bit behind, but I also don't want to stifle conversation. Subchapter 5s tend to move pretty quickly. They do move a little faster than the non-Subchapter 5 small business cases. There's probably a little bit of selection bias in that, in the sense that Subchapter 5s, they're taking probably the easier cases go into Subchapter 5, and the ones that don't qualify as Subchapter 5 have something a little bit different about them. Maybe that's why they're taking longer. But they don't hang around longer if they're going to be dismissed. They seem to take about the same amount of time. So they really does seem to be that they're accomplishing at least one part of their purpose of getting things in and out. And I guess, would you like to talk about these the statistics? Oh, sure. All right. Well, just as you can see, we have some statistics here from the Eastern District of Michigan for the last 4 years. You can see Subchapter 5, the orange, is growing as a percentage. I mean, it's pretty much most of the Chapter 11s that are out there now, and most of them, 2/3, are coming up with a discharge at the end. So it seems to be working. So that's good, because I mean, if you're familiar with the standard Chapter 13 cases, the average, I think, is something like about 1/3 to 40% that actually make it through their plans. So this potentially is heartening. And this is a little bit hard to read, but 60% of Chapter 11 cases in Northern District of Illinois are also Subchapter 5. So this is not just local to us. This is nationwide. Subchapter 5 is here to stay. And you can see that the little graph here that they provided, it's a little difficult to read because the most recent graph stops in May, because that's where we are, and it shows only like 2 cases so far as of when these data were pulled. But Subchapter 5s are growing here as well. And again, all of the stuff is in the deck, and if anybody wants, just send us an email. So that is the overview, and at that point, this is where I stop yapping so much, and we get other people talking. So let's talk about some of the first questions. And if anybody has a question, if you put your hand up, we'll try to take them along the way. But we'll kick off one discussion point. Is there's been complaints that creditors are disadvantaged under the SBRA. They don't have the same rights that they do under Chapter 11. Is that really true? And I think, Kim, you said you would like to talk about those.
Is it not? Okay. So this is something that I think was kind of the perception at the outset, that creditors can be disadvantaged because you don't have the same voting power that you have in a regular Chapter 11. However, you still have a lot of the same objecting power. Really the only thing that goes away is the absolute priority rule, but a debtor still has to propose, a plan that's fair, that's going to meet the best interest test. But when you look at what the debtor's going to disperse over the period of the plan, is it going to be as much or better than Chapter 7 liquidation? And so coming from, even though I'm a Subchapter 5 trustee, I can speak from representing creditors in Subchapter 5 cases as well, that there is still tremendous leverage. If a debtor proposes a plan that's inherently unfair and does not comport with the code, there are really strong bases to object and to insist on a better payout, and the judges are really looking to that. Is the debtor meeting all of the applicable requirements of Section 1129? And so it just does require creditors to be more active in terms of, if they really think they're going to be treated unfair, objecting to the plan. But I think there's still a lot of tools available, and having a trustee involved, it's different than an unsecured creditors committee, but the trustee really can help think up ways to facilitate a better resolution. I mean, I really look at our role as it's not just about getting creditors to come along and agree with the debtor, but if the debtor is offering something that's just untenable for creditors, really working with debtor and debtors counsel to rethink how they're making disbursements. So I think there's still a lot of tools in the toolbox that can be used by creditors.
And I agree with Kim on that. From a Subchapter 5 trustee standpoint, being more of a business operator, financial advisor than a counsel, and I always joke I'm several credits short of my law degree. But I've been called upon by our judges, by our trial attorneys, UST's office to testify to the viability of a plan, to be really asked, on the stand, do we believe that this plan is the best plan put forward? And there's been occasions and times where, based on my analysis and my team's analysis of what we're seeing and where the direction of the business is going, and numbers don't necessarily lie. And it was interesting at the beginning when the SBRA program took off in February 2020, and we had the $2.7 million ceiling. I mean, these were really, really small businesses. I mean, you asked them about their cash flow, they would open up their Bank of America account or Comerica account, whatever, and say $12,000. You'd say that's your cash balance. That's not your cash flow. So, and a lot of them didn't even have books and records. They kept the old school type ledgers where you blew on it to get the dust off of it, and they need a lot of handholding to get through it. And with the new ceiling at the 7.5, it's expanded and it's opened up to some. When I use the word sophisticated, I don't mean to be disrespectful to some of these small businesses, but now you've got a controller, a CFO, some other people other than just the mom and pop type people that are running their business. So you're able to really do a better dive into the books and records, and you can see from the numbers, you can see the direction where it's going. You look at the market, and you can make a pretty fair decision on behalf of the debtor and on behalf of the creditors. Because as Kim said, I do completely agree that although it states in our handbook that the goal here is to get a consensual plan, I do feel that we are obligated to look out for the creditors as well. And I will stand up there in the 10 hearings and say, I've tried, and I don't think that this plan is going to work despite our best efforts. And I think there's better ways to work with it. So, and our judges, our UST's office, very much take into our account our opinion, and have ruled in favor of a lot of what we've had to say based on what our job is and what we're supposed to be doing.
For me, I rely heavily on what the Subchapter 5 tells me. I'm not an accountant. I'm not a financial advisor. That's not my role. But I have to make a decision. Is this plan feasible? And will they be paying out? And do they have the ability to pay out pursuant to the projections they're required to provide? And so how does a debtor in a traditional case normally do that? They put on their chief restructuring officer or their financial advisory firms that they've hired who've prepared the projections and testify, and they're subject to cross-examination. There's an active creditors committee or bank who is going to challenge those projections and challenge feasibility. So you have a robust process. In a sub 5, at least in Flint, and I think right now 96% of the sub 5s that I have, and I have more than I think any other judge in the district, are sub 5s. So so I rely very heavily on the sub 5 trustees. Kim is a lawyer. She's not a financial advisor, although she's over time has become very knowledgeable about projections. But I'm still relying on her for that. Matt obviously is financial advisor, so maybe a little more facile with those issues. But that's an area where creditors can really make hay, because those projections can be challenged, and you're entitled to challenge them. So I would encourage you to think about that. The other point I would make is just simply, and this is what I find something odd about the statute, the goal of the sub 5 trustee is to get a consensual plan. A debtor is discharged essentially on confirmation of a consensual plan. But if you're concerned about the debtor and the debtor's ability to pay, or you're concerned about post-confirmation activities in the business or what have you, it seems to me creditors are better off with a non-consensual plan, because then the Subchapter 5 trustee stays in for a longer period of time over that full plan payout. So it's sort of like, on the one hand, their goal is a consensual plan, but from a creditor's point of view, I almost never understand why a creditor wouldn't want the trustee to stay in, why you wouldn't want another pair of eyes looking at it.
The other thing I'd like to add about the trustee's role, I mean, certainly you can seek appointment of a Chapter 11 trustee in an ordinary Chapter 11, but there's still some power to do that here. And so in some cases, the Subchapter 5 trustee has a list of additional duties that can be added if there's a party in interest who seeks the trustee to have those additional duties. And they include, an investigation of the debtor's books and records, and filing a report to indicate what's found in that. And so there's still also some incredible tools to help creditors to kind of get daylight on what's really going on with the debtor. And if they think that there's any misconduct that's been going on, or, funds that have been, leaving for potential fraudulent transfers, then the trustee can step in and start looking into those things. And in some cases, the trustee can be, appointed all the way up to doing recovery for Chapter 5 causes of action. So there's also those types of things that, you have somebody at the ready. It's a little bit more straightforward to get a trustee appointed with those enhanced duties if it seems like it's an appropriate case. And again, just in a recent case on the creditor side of it, we were able to, with a lot of, it was pretty straightforward to ask the court, we think there's been misconduct here, please have the trustee do the investigation. And the court was willing to grant that.
I'd add one thing and then we'll get to the next question, but also don't forget, if you're a secured creditor, all the rules of protection of your collateral still apply. So, I mean, use of cash collateral is, like if that's your cash collateral, then you're entitled to adequate protection of it. If it's your, mortgage on that property, you're entitled to adequate protection to make sure that that's done. So that hasn't gone away, and secured creditors should keep that in mind.
What success level have you seen of not just getting confirmed, but payments being made, 2-3 years down the line in terms of small companies, which have ebbs and flows? Just, the way 13s have a lot of cases that get dismissed 3 or 4 years in because they can't make the payments. How often do these kind of cases succeed? Do you know?
So far, I'm not quite sure if we know, because it's such, it would have to be the creditors who would flag for us after substantial consummation. The creditors would have to say, hey, we're not getting paid. And I haven't heard anybody say they're not getting paid, but there's also, financial consideration. If you're getting 10 cents on the dollar, which comes out to maybe you're getting, $10,000 or $20,000 and you received half of that, going to the court for relief might just not be economically feasible. And so I haven't heard anything, so I can't speak to whether or not that's because these debtors have been very successful or because it just hasn't made economic sense for the creditors to come back to bankruptcy court.
I think this has been more of an exciting time for the SBRA. When we first kicked off, as we've mentioned many, many times, it kind of aligned with when the pandemic started. And for those first couple of years, I don't think I'm wrong saying this, but a lot of plans that were being filed was a moving target. I mean, especially if you're in certain industries like the hospitality industry or, restaurants, hotels, things that were truly limited to, certain directives by either the federal government or the state as far as how many people can be gathered in a location or if they can even come back. So I think a lot of plans were being put forward because you're almost saying, well, let's take a chance on it. At least I've done probably about 75 sub fives now. I'm from Chicago, by the way, so there's a little bit more there. So let me add that in there. But a lot of the restaurants, a lot of the hotels, a lot of the hospitality industry, sub fives that we had. I mean, as much as I love projections in 5 years and trying to figure out, you're really guessing when things were going to come back or when things were going to open up again. And, you had that moving target. So kind of going with what you were saying, Pete, is you really we had a couple of them. We had a well-known pizza chain in the Chicago area that we put a plan together that we thought, okay, this was a pretty conservative plan. The creditors are going to be patient. they couldn't even hit a very, very conservative plan. And so we're now 2 years past post-confirmation, and I've actually gone back in to try and see what we can do to help fix it and get it back up to where it needs to be. And we've come to the decision that we're going to just have to sell it, liquidate the real estate that they own, sell everything, and we're going to have to try and reintroduce everything from a plan standpoint, because this business wasn't able to survive years later. And the creditors were very patient. I mean, they knew they weren't getting paid, but the alternative was if it shuts down, they might not get as much. So
you have also the statute says you're projecting disposable income over a 3 to 5 year period. You can say when 3, when 5, and I don't know that I have an answer, but it's 3 to 5 years. The statute was enacted and went effective in 2020, and it really didn't kick off, at least in the Eastern District of Michigan. You saw the big spike in those cases in 21. So we're not even 5 years in. So plans that were 5 years haven't even tried to hit completion yet. And we're just now getting the 3-year numbers. So I don't think we'll know how successful these are, at least in terms of your question, for maybe another 2, 3, 4 years.
Another interesting nuance in the code provides that if a plan is confirmed without the consent of creditors, that the debtor can come back and modify the plan freely at any time. And so a debtor who knows they're running into trouble and can't make the plan work can also come back to court. And so it's not necessarily like the end of the world if you get a plan confirmed under 1191B without the consent of the creditors, because you get a little bit more flexibility as a result. So another interesting thing to keep in mind, in terms of success level for debtors.
I think that brings up a question. There is some oddity in there probably are some bugs that we need to work out, because the idea that a non-consensual plan is more flexible than a consensual plan would not necessarily run in the way most of us would think it should work. And I think Judge, you wanted to talk about that weird situation you found about not liquidating debtors, because you can liquidate as well as reorganize. Liquidation is kind of reorganization about non-consensual plans versus consensual plans. Do you want to talk about that briefly?
Yeah, but before I do that, I just want to, so there are a tremendous number of bugs in the statute, as you'll see, but the ABI did a final report. They had a task force that's been following this. They were the big proponents of this, helped draft it, et cetera. And they just released their final report and recommendations, which have now been given to Congress. One of their recommendations, of course, is to keep the debt limit at 7.5 million. There was talk about raising it to 10 million because the cases have been successful, at least getting confirmed. The oddity that Ron is talking about is that in some instances in a liquidating plan, because a debtor can still liquidate in a Subchapter 5, is that a liquidating debtor in a non-consensual plan, under the way the code is written, can get a discharge of its debts. But a consensual plan, you can't. And that's just the way the code is written. It applies. There's the first section of Subchapter 5 says these are the sections that don't apply in Subchapter 5 or aren't applicable in Subchapter 5. And one of those provisions seems to exclude the possibility of getting a discharge in a liquidating plan where the plan is consensual, which is clearly something that was not intended. I can't imagine anyone would intend that to be the case. So.
Although, from a practical standpoint, if the debtor is being liquidated, maybe there's no discharge, but there's just a shell. So what are you going to go after, right?
I mean, the end result may be the same regardless of whether it's one or the other, but clearly you would think that in a non-consensual plan where people are voting against the liquidating plan, the discharge would be a little harder to obtain. But that's just.
Do you want to? I guess since first of all, we can go a little longer if you guys want to, but we are coming up on our time that we've reserved. So if anybody needs to leave at 1:30, we understand. We can talk about what happens if no creditors vote, or we can talk about Subchapter 5 is getting paid. You're the audience. Do you have a preference where we go next? If not, we'll leave it to the panel.
There we go. I think what's really come up a lot lately is the whole situation when a class of creditors don't vote and how that plays out. because we know that there are certain scenarios in which, like the SBA, for example, will not necessarily vote on a plan, or we've seen banks that will not vote on a plan because they're SBA backed, and they know if they do that, they might not get the guarantee on their loan. So those are always kind of tricky situations in which, on a couple cases that we've had, where we've had a class of creditors that don't vote, but they also don't object to the plan. We've had it where, although it's considered a non-consensual plan, the Subchapter 5 trustee doesn't necessarily have to stay on as the dispersing agent. So that's something that has been very much been in the forefront of some of the cases that we've had, just to basically relieve the Sub 5 trustee of having to stay on and being an additional cost to the estate. So I've always found that to be kind of an interesting topic of what's going on, because there's been quite a bit of arguments back and forth of, whether that should be the way things go or not. But I'm kind of curious of what you guys have seen in your district.
One of the things, so for a non-consensual plan, the trustee, unless the court orders otherwise, the trustee is the dispersing agent. So that's actually like a good leverage point too, because if the trustee stays in as the dispersing agent and that's what the creditors want, then there's an additional expense going to the trustee for that over the life of the plan. So I've suggested to some debtors that, hey, like put in, 2 different scenarios of budgets. Here's one, with consent, and here's one without. It's not a big number that you're going to have that's coming out to a Subchapter 5 trustee over the life of a plan, but it's a reason to, maybe it will encourage creditors to vote in favor of the plan. But I also try, if I can, to encourage debtors, if in the right circumstance, to write into the plan that the trustee won't be the dispersing agent, so they don't have that extra burden. Because really, what's going to happen is it's just the debtor writes a check to the trustee deposits it in the estate account, and then makes the disbursement. So it's just really a little bit of a redundant task. There is some level of oversight that I think is worthwhile to get from a Subchapter 5 trustee over a plan, and that's probably a better placed role than dispersing funds for the debtor.
Yeah, I would agree with that. But the cost associated with having the trustee be the dispersing agent or the debtor be the dispersing agent, and I've seen cases, non-consensual cases, where the trustee and the debtor have agreed that the trustee is essentially assigning that responsibility back to the debtor with the consent of the court. And I get to opine on whether that's permissible, and it's a cost factor. This is really more of an issue. I mean, it's an important issue, and it is an issue. There's 3 different sort of tracks. Some say that silence because no class voted. And it's usually, there's typically each secured creditor should be separately classified. So theoretically, each secured creditor, each bank, each lender in some fashion or other can decide whether or not it's going to be a consensual or non-consensual plan, depending on whether they vote against the plan or if they simply don't vote. So if they don't vote, some courts say, well, that's a rejection. So now it's a non-consensual plan. Some courts say, and this was the most recent one, I think that you just don't count it at all. It doesn't factor into anything because you have to have, a number voting in order to be able to calculate under the bankruptcy code whether you have an accepting class. So if no one votes, you have no numerator and you have no denominator, so you can't do the math. Other courts say no, it's like you can't infer rejection or acceptance from silence. You have to deem it rejected. This is really more of an issue in a traditional Chapter 11 case, because you need an accepting impaired class in order to cram down. But in a Subchapter 5, you can cram down if every class votes against the plan. You can still confirm the plan, you can still cram down. So while this does matter in terms of who's dispersing, it doesn't really matter for plan purposes, I think. And that's the weird thing about the Subchapter 5 is you don't have to do a disclosure statement, and you don't have to go through the time and expense of getting your disclosure statement approved, but you still have to ballot, and you have to send out the plan and solicit the votes of creditors, say, do you like this plan or not? And they can all say, no, we hate this plan. And the court can still say, I don't care, I'm confirming it. So I don't think this is really the issue for Sub 5 as a main one.
Situation where the plan is not confirmed. People have voiced that they're going to object. Creditors have said they're going to object. Bank is petitioned to offer some form of payment concession, let's say interest only over some protracted period of time, in efforts to get the plan approved, but doesn't want to vote itself that it's an SBA-backed deal. Does, by virtue of offering that payment concession, kind of intimate that they're voted for the plan, even though they're not voting yay or nay against the plan because they offered the payment concession?
So I think just having worked with the SBA on some of these things, I would really be looking to the guidance from the case manager for the SBA on whether what should I do as creditors counsel. And so if they tell me that you can object, you can give this payment concession, but you can't vote on the plan, that's what I'm going to follow, because I know that my client is, not going to be, it's not going to affect my client's SBA guarantee. And so I think that's the biggest question, is making those decisions can't be made just by the lender, the SBA backed lender. It has to be done with that case manager. So I guess that's as simple as it is I will only do what I'm told I can do. And so I've stipulated and agreed to confirmation of plans without voting on them, just because they, provided some sort of treatment to my client. But those things are all vetted through the SBA's process of determining whether or not, concessions should be granted.
I think if I understand the question, it's not just that, but it's also, given that you make that, they take the action, what should the court and the Subchapter 5 trustee take from that position?
Well, we just had, I think David's here. We just had this issue in a case that David Lerner was working on with me. Yeah, he's back. But, and there were certain things that he couldn't represent because he didn't have the SBA's approval. But he wasn't opposing the plan. And there were accommodations that, as the secured creditor and the SBA, presumably the debtor was, or the bank was willing to make. So we confirmed we treated it as non-consensual because the SBA didn't authorize him to vote in favor or to change. Actually, I think they voted to reject. And then the question was, did he have the authority to reverse that vote? And he didn't. And so we just went ahead and said, okay, you're not objecting to the plan, but you're not voting in favor of it. And so we just confirmed a non-consensual plan. Again, I mean, the rejection is an important indicator for the court to say, I should look at this more carefully because creditors seem to be, opposed to whatever is being proposed, but that doesn't prevent the court from confirming it, even if it is opposed.
Looking for any more hands and see if there's any other questions. All right, seeing none, how about this? Well, let's end on, from each of our panel, from the bench and from our Subchapter 5 trustees, what can when people find themselves in a Subchapter 5, what can we do to make it go better for everyone, creditors, for debtors? Any thoughts on what things people should be doing?
From the creditor's perspective, I think definitely, seeking, assistance from the Subchapter 5 trustee, expressing your position and any concerns you have early in the case will be really helpful to the Subchapter 5 trustee's job, and really the kinds of tactics that the trustee chooses to use. And so that's something that I think on the creditor side. On debtor side, I think it's really making sure that you're going to have an administratively solvent case, really, getting us paid, but also just getting all of the administrative expenses paid. And, so being able to have good cash flow projections. If you do have a debtor who doesn't normally do that kind of stuff, getting a financial advisor involved early on would be another useful thing to do to keep things moving smoothly. And it's really just, keeping the Subchapter 5 trustee involved and aware of what's going on throughout the case. We can take a very passive role, which is very inexpensive, but the more we know, the sooner we know it, the quicker we can step in and spend less time getting to know what the issues are. So just, really relying on the trustee to be that person who's basically mediating between debtor and creditors would really, really helps the case.
I would say that from my side, from being a sub 5 trustee, and then also being an FA to debtors, whether in a traditional Chapter 11 or Subchapter 5, is really educating and getting a sense of, and I know this is a lot of what debtors counsel's responsibilities are, is what they're really getting themselves into. Because I think at the beginning, and it's gotten much better, and as we've talked about, there's definitely still bugs to fix out, but people think, I've heard all the time when coming in as either a receiver or a signee, whatever, where a debtor or a company's like, well, I'll just file bankruptcy. And it's like, do you really know what you're getting into? Like, do you really understand what's going on here? Because, getting into bankruptcy, is great of a opportunity it is for companies that really need to reorganize and restructure. It's there for a reason, and people deserve to have second chances, or for some third, fourth, fifth. But I think really educating, and what I try to do as a sub 5 is with debtors counsel's permission, and I really don't need it because I'm not counsel, and so I can speak with the debtor when I want, I believe, but explaining to them, like, here's what we really need to do. Like, this is not just going to be a push of a button and it's going to say, well, that was easy. There's a lot of hard work that goes into it. You're really going to have to make some difficult decisions, and I always tell debtors in all these situations that the moment that you are rendered insolvent, whether a month before bankruptcy or 6 months before bankruptcy, the cap that you're wearing changes. And I tell people this all the time. Obviously you have an obligation to your business, you have an obligation to your employees, but the moment that you are rendered insolvent, and you're really seeking the bankruptcy protection, you need to start thinking about what it's going to take to go into bankruptcy. You really need to switch that ball cap that you're wearing to what can you do as a fiduciary responsibility to your creditors. And although it's, you want to come out of that bankruptcy having as much success and less debt as possible, I'm not an advocate of that. And I believe that there really needs to be a fair balance, and debtors have to understand more that they do have that responsibility of paying out as much as they can. And if things come up down the road where there's more money that's, found, and I've found situations where we've discovered the business is doing far better than we anticipated, even though that the plan has been filed, there's certain obligations I still think that are out there for those debtors to continue to make sure that those creditors are made whole. So from a Subchapter 5 standpoint, from a creditor standpoint, just continuous communication. And I think as we continue to fly this plane, as we build it, we'll continue to make improvements on it.
Well, I certainly agree with that. I think when a case is first filed, I think the debtor and the bank have all the leverage. Unsecured creditors don't have a lot of leverage. But with the subchapter trustee coming in, I'm finding that their early involvement and the lender's early involvement forestall a lot of problems, because I see a lot of very small businesses come in, and it's not necessarily fraudulent, but there's just no sense of controls. I mean, they treat it like a personal checkbook, and they're going to continue to treat it like a personal checkbook. And it's not necessarily fraudulent. It's just that's how we ran the business. And now suddenly they have fiduciary duties that run to creditors, and they have responsibilities of reporting, and they're just not geared up for doing that. And so when a lender comes in and says to them, if you want to continue to have a relationship with us, you're going to have to put in controls. You're going to have to put in some sort of financial advisor to at least help to be able to put together your monthly operating reports and your projections, et cetera. And with the subchapter trustee telling them the same thing, you can at least get control early on and see whether or not this is a feasible case. This is a case that could survive. And I think that the early involvement is really what's most important in the success of these subchapter 5s. So 60 days into a case, the plan has to be filed 90 days. 60 days into the case is when you have this status report and status conference. The report has to be filed in 45 days, but you're supposed to get together in 60 days and sort of be able to say, here's where we're at, here's the progress we've made. By the 60th day, if you're hoping to do a plan in 90 days, that's too late. So what we do in the Eastern District is we have scheduling conferences where we set the dates for when the plan is due, when balloting is due, objections, et cetera. And we use that as sort of the initial status conference so that the U.S. trustee and the Subchapter 5 trustees and the debtors and the banks can all get together and sort of say, these are the problems that we had pre-petition, and these are the problems that we see continuing in this case if steps are taken early to resolve it. And that's where, the lender and the lender's professionals and the Subchapter 5 trustee really play a critical role in the success of the case.
And I'll just say, for the secured creditors out there, watch your collateral and get in early, because, that's still your collateral and it has to be treated like it would be in a Chapter 11. So, if you think, oh, it's just a Subchapter 5, I'll take my eyes off the ball, then that's not good for you. At the same time, if you have the collateral and cash collateral is necessary, you have some control, because if they want consensual use of cash collateral, you can build stuff into that cash collateral in order to make sure you have protections, and you can help the debtors you think are going to make it through and prevent some of the, how does a lender say gently, atrocities? No, mistakes that might otherwise be made. So, that's your opportunities to watch your stuff and to remember this is not just a small, tiny little thing. This is a Chapter 11 bankruptcy, just like any other.
It's even almost more important. The irony is they're smaller dollars, so banks may be less willing to spend the money to really closely monitor their collateral. But, I've seen cases where people are not, the debtor's lawyer don't know that, well, I need permission to use cash collateral. So they're out there spending money, they're, going along, but the lenders aren't coming in and saying, hey, wait a minute, this is my collateral. You're just dissipating, at a club. And which, by the way, that actually happened in a case in front of me. I mean, there was like gambling going on. It was crazy, but it took a while for the lenders to gear up and come in. Once they did, and they were like, whoa, they were able to stop, that, and the dip was removed and they put in someone else. But it's really important early on, because a lot of times in these, particularly in the smaller cases, I mean, we're talking about, one or two tire and auto repair shops. They're going to act how they're going to act. And they may be entirely innocent but ignorant, and it's up to you to say, well, wait a minute, that's, you can't do that, and you bring it to the court's attention. And if you don't do that, by the time the subchapter trustee figures it out and they do that or talk to you about it, you've lost a lot of money. So
yeah, lenders, don't be asleep at the switch. And of course, none of the lenders in this room, only the ignorant people are, we can speak freely because it's, the smarter people are here, which is good. No, I think that that's a. I heard a comment, but I won't repeat it. They're smarter now. No, our group here is the people in who come to events like this are staying on top of things, and they know, which is good. It's but it's new to everyone. We're all learning, and so I guess I would say thank you all for coming out and for bearing with the traffic and the traffic's effect on our delay on food. Thank the panel for their time, and for you all for being here.